Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started. Good evening, everybody. This is Omar Serrato with the Tilted Lawyer Podcast, and I guess we're live and we're ready to go, and we're going to do some Blake Lively stuff. There's honestly not a whole lot that is going on. What about now? Could y'all hear me now? Technical difficulties at 10 p.m. Oh, I guess it's fixed. Well, hell, let's do the show then. How do I get this off? Stop it. All right. We're ready. Okay, look, let's try that again. So everything's going wrong so far. I was supposed to have Anita on the show with me. I don't know where she's at. She's probably overslept. It's like a 7 a.m. where she's at. And so if she pops back in, she has some new stuff with us. But in the meantime, look, as far as the litigation side of all of this, it's not that big of a deal that Lively has withdrawn her emotional distress cause of action. She didn't want to hand over her medical records. It doesn't matter why she didn't want to hand over her medical records. The consequence of that is she cannot use emotional distress or anything medically related to her emotional distress for other causes of action if she wants to withdraw that claim, because now it's going to cause Wayfair parties to be unable to discover those documents or to compel the handing over of those documents. And so, Alicia, thank you so much. I appreciate you. She probably is a liar, Penny, but I have no way to compel her medical responses anyway. What were we going to find out? I don't know. Maybe that she hasn't really been visiting medical professionals to figure out whether or not she's been emotionally distressed. I don't know, but she didn't want to do it. Maybe there was something really embarrassing in there that she didn't want to get out, like, hey, sometimes people go to get medical procedures that they don't want publicized to millions of folks. And so I don't blame her for not wanting to disclose medical stuff. What bearing does it have on this case? I mean, not a whole lot, other than she's just not going to be able to use that stuff. And it's something she's going to have to deal with. I'm sure she's fine with it. So they're getting rid of that. What is this? There was a letter that Baldoni, that Freedman had wrote. He wrote in a letter that Kevin Fritz, he was arguing that Lively has refused to produce the evidence needed to disprove that she suffered any emotional distress, but he wanted to dismiss those claims without prejudice, meaning that she could potentially refile them after the discovery period closed, which is kind of bullshit. Look, if you're going to get rid of them now, then dismiss with prejudice. If we're not going to deal with this now, I don't want to have to deal with it ever. And so that's kind of the points. Other than that, I don't know what else to read into it. There's a dispute about evidentiary stuff, a dispute about discovery. I could get into like the legal ins and outs and strategy of why that is or isn't. I'm not entirely positive that it's helping or hurting Blake Lively's case. I don't think that it's, in the grand scheme of things, really anything all that important. So there was that. There was also, I noticed as of today, a brand new amicus brief that was filed, and I wanted to go over that because I went over the other one on Friday, and I thought that it was kind of frustrating to read in terms of what we know about 47.1. My personal opinion on 47.1 that I had talked about on my Friday stream was that I believe that the way that it is written, that if you have 47.1 as a deterrent to people who want to defend themselves from claims of sexual harassment by stating that they are being defamed as a result because they think that this is a frivolous complaint. Well, the consequence of that is if you're wrong, triple the damages. And so there's a long line of cases, and I'm talking about going hundreds of years deep, that stand for the proposition that we don't punish unnecessarily unfrivolous lawsuits. So if there is a modicum of arguments to support your position for defamation, you shouldn't have to be penalized with 3 times the damages that you would normally incur. That is an extreme deterrence in the opposite direction. The proponents of AB 47.1 would suggest that defamation represents a chilling effect on those that want to come forward. I would argue that the opposite is happening with the way that it's written. You cannot defend yourself with defamation without this extreme fear that you're going to be penalized if you don't meet the high bar to prove a defamation case. They're not that easy to prove. And so to the extent that that's what's happening to Justin Baldoni, there's a lot of opinions out there about whether or not he should withdraw his defamation claim. I don't share that opinion. Very early on, look, it's not an ironclad case by any means. There's weaknesses in his defamation claim. There is dots that he still needs to connect, that has been left wide open by virtue of his pleadings. And whether or not he's going to be able to connect those dots is going to depend on what comes out in discovery. But there's been other people out there that have suggested, hey, maybe we should just get rid of the defamation because it's a little bit too much anxiety riddled to continue this way with the amount of damages that Lively is claiming and treble damages and whatever. My point being is if you believe in your case, then you believe in it all the way, and you believe in it in the face of losing it. And if the monetary penalties are too much, that would that is a deterrent. But at what point do you lay down your sword because you think that, if you're captured, then you're going to be tortured and suffer a slow and painful death, or you go out there and you die on your shield? What are we going to do? I don't know. I guess that's the question that we're asking. What is with this popcorn yellow striped smile thing? I've heard that a couple times in the chat so far. What is going on with that? What am I missing? Ricardo, thanks for being a member for 2 months, man. I need to collab with you. Not actually golden, ASAP. Shoot me an email or a DM on Instagram and we'll hook that up, Ricardo. I would love to do that with you, by the way. I have a collab coming up with Rachel Juarez tomorrow, the judge from the hot bench. She is the other person that has drawn the ire of David Gingras. Getting back to these amicus briefs. I wanted to read you what a letter to Judge Lyman written by Freedman in his opposition to these organizations that are writing amicus briefs. I'm aware of 3 of them. One just dropped today. I'm going to go through a little bit of it. The one that we read regarding Elise was making claims that I addressed on Friday. I was just not in agreement. It was kind of upsetting the way that they were framing these issues. And I think the problem with these activist organizations coming in and trying to insert themselves into the case is that they are coming at it from a lens that is extremely narrow and just short-sighted as to the effects of what would actually happen. Because look, 47-1, I think it was adopted in 2023. There's not much direction on how to interpret these claims, these cases involving 47.1 with damages. And so this case, Lively versus Baldoni, whether it likes it or not, is going to become a landmark case in the legislation of 47.1 insofar as how California courts and federal courts that are forced to contend with 47.1 are going to have to deal with these in the future. So without further ado, let me get my tabs in order. I'm going to share with you this letter I wanted to go over with that Freedman had penned. And this is it. Is it? I don't know if it's it or not. Yeah. Make sure that's on the screen. It is. Hey. You got to take your wins where you get them. Oh, crap. It's all the way over there. Okay. So, well, here we go. So Freeman starts off to Judge Lyman. Wayfair Studios, Justin Baldoni, the formalities, whatever. As described below, the court should deny the organization's motion for leave to and file an untimely, partisan amicus brief that merely serves as a vehicle to renew, lost my place, to renew Blake Lively's public attacks against the Wayfair parties, repeat arguments previously made by Lively, and raise issues that are irrelevant to the pending motion to dismiss. While the Wayfair parties respect the 3 organizations seeking amicus status, their brief fails to aid the court in its task at the pleading stage. If for any reason the court grants the organization's leave to file a brief, the Wayfair party should be permitted to file a responsive brief. As an initial matter, the organizations filed their belated motion with Lively's consent almost 2 months after Lively's motion to dismiss had been fully briefed, enabling Lively to resume unwarranted attacks on the Wayfair parties with inflammatory comments to the press. The motion serves more as a publicity stunt for Lively than a useful aid for the court's pleading at this pleading stage, which, they're arguing policy reasons. They're not arguing case law. Is it a publicity stunt? I don't know. I'd imagine for the people that wrote the briefs, sure. In the grand scheme of things, I did not read it as a publicity stunt. What I read the initial amicus brief on Friday was as an activist organization that sought to shape the tenor of legislation regarding sexual harassment claims in California. And I think they had their own agenda. I don't think that Lively really played much into it. I thought that if they were looking, they're using this case because of the platform. But I think that there were far greater cases where they might have made a louder splash in filing an amicus brief. But here, look, they're taking advantage of the audience. So there's that. Freedman goes on to state the circumstances under which an amicus brief is considered to be an aid to the court are limited. An amicus brief should normally be allowed when a party is not represented competently or is not represented at all. When the amicus has an interest in some other case that may be affected by the decision in the present case, or when the amicus has unique information or perspective. And I know that some of you would argue that Lively has not been represented. Well, I don't know if you guys would say competently. I think that some of you guys would say that she hasn't been represented ethically. I think that's the better description of what some of you guys think. Where these circumstances do not exist, leave to file an amicus brief should be denied, especially where the competence and skill of a party's counsel obviates the need for additional inputs. There is no inherent right to file an amicus curiae brief with the court, particularly where the applicant's only concern is the matter in which this court will interpret the law. The organizations do not assert that Lively's counsel is incompetent, nor do they identify any other case that may be affected by this court's decision on Lively's motion to dismiss. I think that was implied in their argument that this is going to be, I think the implication is that this is a landmark case that will affect hundreds of thousands of these similar kinds of cases in the future. I think I would disagree with that. We're going to leave off. Champions of California bill. Okay. The organizations rely on their unique perspective as drafters and champions of California Assembly Bill 933, which is another way of saying that the organizations attempt to provide disguised, premature, and inappropriate expert testimony at the pleading stage as observed by the Seventh Court. The vast majority of amicus curiae briefs are filed by allies of litigants and duplicate the arguments made in the litigants' briefs, in effect, merely extending the length of the litigants' briefs. Such amicus briefs should not be allowed. They are an abuse. And he cites a long string of cases as to why that is. While the Wayfarer parties respect the work of the organizations, they are not neutral friends of the court, but rather advocates of specific policy interests that align not only with Lively's defensive posture, but also her affirmative claims against the Wayfarer parties. In addition, the proposed brief raises issues that were not presently or presented by Lively. The proposed brief focuses on the need to avoid abuses of discovery in sexual harassment cases, which is an issue that was not raised by Lively, who did not move for a stay of discovery and in any event is not applicable to this dispute given Lively's pending affirmative claims. Discovery is well underway. These arguments are in a posit. Finally, the proposed brief violates the timing guidelines used by district courts for such briefs. While the federal rules of civil procedure do not address the submission of amicus briefs, district courts have looked for guidance to Rule 29 of the Federal Rules of Appellate Procedure, which provides that an amicus brief and motion for leave must be filed no later than 7 days after the principal brief of the party being supported is filed, and there's been like a 2-month gap or something like that. The organizations filed their proposed brief more than 2 months after Lively filed her motion to dismiss, well beyond the window, as the Wayfarer parties would need time to respond to the proposed brief. A decision on Lively's motion to dismiss would be further delayed by its inclusion, weighing against granting leave. And for the foregoing reasons, we don't want these amicus briefs lodged. So there is Freedman's opposition, and really, he makes some case law arguments. Really what they are is a procedural decision. I think that the simplest thing for Judge Alignment to do is just to simply deny them because of the procedural technicality. I don't believe that they're necessarily helping at all. Lenore, there's been a couple others. There was Ezra's organization. They filed an amicus brief. Interestingly, I don't know if any of those amicus, I don't believe any of those amicus brief motions were granted. So they're on the docket. You can read them. Whether or not they're going to be accepted by the court is another issue. Freedman is opposing. There was another one filed today. I'm going to go over that one for a little bit. Are they helping us get anywhere with this case? No. I mean, the judge is not going to rule on this case for one. What is he supposed to do with this information? Like a 47.1, it dictates, it mandates certain penalties for certain results for a defamation claim in defense of a SH claim. It's what it does. And then it gives the judge no ability to mitigate those damages. They just are what they are. They are treble damages. So even if he agreed, for example, against the damages, he can't do anything about it. And so what is this for? I mean, this belongs as a policy discussion in a legislative hall somewhere where they're drafting possible amendments to 47.1. The fact that it's landed here on the court docket is because activists are trying to get their points of view out. 47.1 has never had so much attention, I'll tell you that much. KS says, I was suspicious that No Teeth knew about 40. Who the hell is No Teeth? Is that Blake Lively? It is. Knew about 47.1 getting signed into law before it was active, but the connection to Hudson and being on the board of that org confirmed it. Well, I don't think Lively knew, but Ezra certainly did. Ezra is a snake in the grass, man. She is a dirty litigator. She is, all of the things. She has done some things. Her legal team has done some things in their representation of Blake Lively that run afoul of ethics, I think. If she was representing you and she was able to pull off some of these maneuvers that are making it exceedingly difficult for Justin Baldoni to continue in this way, I think that you would be thrilled with her representation. If you're of the opinion that you are in support of Justin Baldoni, then you look at her as a snake in the grass, a piece of shit human being. That's what it is. What's up, MG Law? It's an MG Law raid. Let me check on something real quick. If y'all see Anita in the chat, I'm unable to keep an eye on it. Just to let her know, she's got a link in her email. I forgot what I was getting on about. Oh, about Ezra. Yeah. The fact that she was on the board of that organization with the lease is concerning, because I 100% believe that she was part of drafting the strategy that was to take advantage of 47.1 protections in California, because she was aware of the enormity of legal fees and costs that were going to be inherent in this case and treble damages. And she probably saw defamation coming a mile away. Well, she did what she did. Never mind the Van Sham lawsuit and all of that. We're here because, and you know what? It makes for good commentary. It makes for good content, I guess. Tell Lauren 90 to get some sleep and enjoy her vacay. I did. She was flabbergasted earlier on a text message that they eat kangaroos. Apparently, and I didn't know that either. Is that a thing? Like, people actually, I had no idea that they were like a food source. And then I was corrected. Oh, but they're dog treats. Like, some people feed them to their dogs. I had no idea. I thought that kangaroos were like cool with everybody. I didn't know that it was like a delicacy in Australia, where she is staying. But Lauren is having a great time, and she's doing her thing out there. Helicopter rides and the whole bits. Where was I going with this? Oh, I was going to share with you guys the Amicus brief, the new one. I'm just going to read a little bit of it. I haven't read this yet. I just, when I was going on, I saw that this was filed, and I was like, oh, well, this is a new one. It says it's 42 pages long. I'm not reading 42 pages of this. How much of this is exhibits? Wow, they really put some time into this one. I will peruse it. What are they talking about? So they're going to make these arguments that retaliatory defamation lawsuits silence survivors, perpetuate myths about false accusations, and exacerbate the public health emergency of sexual violence. I mean, that's a stretch. I mean, you could argue that any false claim for any cause of action is perpetuating false myths about false accusations. I understand that people are afraid to come forward with these claims of sexual abuse. And look, I've represented hundreds of clients that were the victims, like genuine victims of these kinds of crimes. And, it's difficult for people to come forward and advance their claims. And part of it is because they're going to have to defend their claims. They're going to be called a liar in court. They're going to have to talk about embarrassing things in court. And in a lot of ways, that is a far greater deterrent than a frickin' defamation counterclaim. When I talk to my clients, their biggest concerns are who's going to be in the room when I'm up there testifying? Are they going to be allowed to ask me questions? Am I going to be cross-examined? Am I going to have to give up my medical documents? Am I going to have to give up my text message history? And, for women or men, for that matter, to have to release their private text messages for somebody that they are dating because they're in the midst of a sexual assault kind of litigation. It's embarrassing, man. There's some stuff on there that you don't want people to see, even if it's being redacted. You got some like little pervy paralegal over there redacting stuff, looking at all your private stuff. Nobody wants that. There's other considerations, but defamation claims, look, you're already in there. Sue me for whatever you want. When people get the resolve to litigate their claims, they're in. They just got to put their game face on and do what they got to do. What this 47.1 ignores is that there is another side of the spectrum. It has been known for hundreds of years now that, look, because there are legitimate claims of sexual harassment and sexual abuse in the workplace, in industries, in your private life or otherwise, it is a move, although it be it a slimy move, to promote false allegations of these sex crimes. Because what are you going to do? You're going to go to court and defend yourself? It's your word against mine, buddy. And guess what? I could cry on command. You wouldn't believe it and you wouldn't think it because, some judges are so steely minded or give the appearance of just being stalwarts that they would not be beholden to emotional displays of tears in the courtroom, but they are on occasion. I've grown very callous when to the sight of a victim that gets up on the stand and before ever saying a word, just immediately bawls into tears. I was like, come on, man. All right, let's be done with the spectacle. So I feel like I've developed this skill where I could tell where it's a put on and when it's just like a legitimate display of emotion. And in every case where I have a client that is defending themselves against these accusations, I would say probably about 75% of the time when I cross-examine these alleged victims, the first thing that they do, they didn't do this on direct exam, but as soon as I start questioning them, the waterworks start, or even the crocodile tears. There's like the whole, the act of going through the motions of crying, but not a tear was found in either eye. Maybe they got some Visine in there, or they got, I don't know. It's just really bad with some of these cases. It's just a short-sighted statute. They make these points. Sexual violence is pervasive and vastly underreported. 47.1 isn't doing anything to change anything like that because the reason why it's underreported has very little to do with cross claims of defamation. Retaliatory defamation lawsuits reinforce the culture of silence around sexual violence. See, that's taking it too far. I got to read this shit. I got to get into this. I'm already getting upset. I'm not getting upset because I'm not supporting victims. I'm getting upset because I know that this pendulum swings both ways. ATUL call it zealous lawyering. Are we talking about Ezra and her brilliant maneuvering? around, utilizing 47.1 in ban sham lawsuits. You can be unethically zealous. I don't necessarily disagree with Ask Two lawyers that they are doing what they can to win. Zealous does not imply good or bad. It implies a style of litigating. That's all. I could zealously advocate for my client ethically, or you could zealously advocate for your client unethically. If you want to call it shrewd, I don't know. You call it whatever you want. Just make sure you slap unethical in front of it, because I don't believe in the slimy maneuvering that's gone on in this case. Are they going to get away with it? I guess time will tell, right? They're going up against a buzzsaw, Bryan Freedman. So, hey, what's up, Rob? Rob says, I'm glad Omar went live. I did not get a notification, but I'm glad I checked in. His legal insight is interesting to me. My legal insight is just a one of many, What's going on, Crow? Because I have an opinion that's different than yours does not make it a troll. At Stirkrick, Crow is not a troll. Crow has been around my show. I don't know how long. I feel like I've seen you for like a whole year at least, Crow. How long have you been around? I feel like the first time I ever saw you in stream that I could remember was on a Wayward episode of Flad. One thing I know about Crow is that she's very passionate. She's not afraid to go against the grain, and she has different opinions, but I welcome all of your opinions that differ. We all don't have to have, these fight to the death disagreements, man. You guys are allowed to disagree. It's cool with me. Anyway, let me get back to what I was, before I get distracted, let me get into some of this amicus brief. So I don't know, guys. To me, the amicus brief is way more interesting, even though it has less to do with anything regarding this lawsuit, just because it really speaks to where we're going with what is the final results of this Me Too movement that started, when was it, back in 2014? It started off with an explosion, the Harvey Weinstein thing. And the pendulum swings one way and then back another, and now it's back the other way again. I feel like there are certain activist groups out there that really do a disservice to victims. And whenever I've learned over time to be weary of activist groups, because oftentimes the person at the head of these activist groups is raking in a shit ton of money. And it's almost like these little cults that they start in the name of social justice, when really the leader of these organizations could give a rat's ass about anybody's victim status, about whether or not anybody's been silenced. They found a wave, a narrative that they can ride into a movement that becomes a money-making opportunity for them to have an organization become a nonprofit and rake in the dough. I mean, that's what happened with, I'm not going to name any organizations. I don't want to upset anybody, but there's been a lot of degenerates that have been found at the tops of these organizations that have thwarted a lot of the good work done by real good, genuine people. When somebody comes to me as an activist, it's almost the same as if they're like knocking on my door, trying to give me, some kind of a pamphlet or whatever. But I take them serious because they're making arguments. They're trying to make arguments. They're trying to shape litigation in ways that are tangible. And so for that reason, I listen to what they have to say. So this particular group is called Child USA. It is an interdisciplinary nonprofit think tank. You got to love that description. Dedicated to preventing child abuse and neglect and ensuring access to justice for survivors. You see how manipulative that is, though. Like, hey, look, come join this group. We're against child abuse and neglect, and we are also for justice for survivors. Nobody's going to disagree with that. Nobody's going to say, oh no, fuck those people. Nobody's going to be like, you know what? No, I think the children should be abused. Nobody's going to say that. And so they get people to join these groups, and then they have like these movements and these camps and these meetings and these charters and these grassroots movements. And it's no different than these evangelical churches that you see that pop up from time to time. And they get all these members and they start radicalizing these members and they send them out to go and make disciples of all the nations as Jesus instructed you. And, you know, they give people a purpose and they set about their purpose, all the while collecting money from their members. There's membership dues, and it's all geared towards ensuring access to justice for survivors. But, you know, only like 5% of it, because the other 95% are going to fund the salaries of the higher ups, right? I'm not accusing Child USA of that. I'm just saying I've seen that go that way for a lot of these places. I'm not naming anybody. For all I know, Child USA, maybe they're great. Maybe nobody's getting paid. Maybe they are the patron saints of activist organizations. For all I know, they're great. So let's just continue. Child USA founder Professor Marcy Hamilton is a world-renowned constitutional law scholar. I do know who Marcy Hamilton is. I didn't know that she was a part of this group, though. First Amendment expert, professor of practice at University of Pennsylvania. Her leadership has positioned Child USA at the forefront of legal. So they're good people, right? The organization has advised Congress, state legislatures, governors, and courts on the constitutionality of revival window legislation, anti-SLAPP protections, other laws aimed at increasing survivors' opportunities to access justice. Child USA has a strong interest in the outcome of this case, which will shape the legal landscape for survivors in California and beyond. Child USA offers this brief to demonstrate that California Code 47.1 is both constitutionally sound and essential to protect the rights of survivors of sexual violence, safeguard the integrity of public discourse, and ensure equitable access to justice. Cheers to that, huh? Summary of arguments. Sexual violence remains a pervasive and chronically underreported crime. Let me just embiggen this for me. Particularly in cases involving child sex abuse. Among the most formidable barriers to disclosure is survivors' fears of retaliation, which increasingly takes the form of meritless defamation lawsuits designed to intimidate, silence, punish those who speak out. These lawsuits drain victims' financial resources and cause them extensive emotional, psychological, and reputational harm. Worse still, they chill constitutionally protected speech, deterring survivors from coming forward and obstructing efforts to expose abuse, prevent future harm, and hold perpetrators and institutions accountable. I'm not going to disagree with them that defamation counterclaims in these kinds of lawsuit do any of these things. Of course they do. In some cases, they do drain financial resources. In some cases, they do cause extensive emotional, psychological, and reputational harm. There is a whole way. Look, trial advocacy is really difficult. Never mind that you have to learn the rules of evidence and how to get in your questions and how to properly ask a non-leading question on direct exam and how to ask leading questions on cross-exam and ask non-objectionable questions. And then there's the arts of presentation and not appearing nervous and, knowing the laws and knowing what you're trying to prove and how to structure a cross-examination. You got to have a beginning, a middle, and end. You got to keep in mind primacy and recency. Nobody gives a shit about the middle parts. People care about what comes first and what comes last. You score well on the first thing. You score well on the last thing. Make sure you put those points for what you want the jury to hear. And there's a whole, I've been doing this 11 years and I still don't think I'm all that great at it. I'm still learning things, but one of the most difficult things to do is to cross-examine some person who has been alleged to be the victim of a sex crime. It is terrifying for the victim. It is really emotional for the attorney. The best example I could think of is the one trial where I was cross-examining these children. They're literally children. They had made claims when they were 9, 10, and 13, that they were the victims of a sexual assault at the hands of their uncle, who looked every bit the part of a child molester, every bit the part. These children, as the story went, were up in a treehouse or like in this trailer because they were camping out. It was like a night, a sleepover night, I guess, after like a family party. I want to say around Thanksgiving or so. The family was there. And so they all get together and they start having this, they start telling these tales about, this happened and that happened and that happened. And they came up with a story together. At least that was the deal. I mean, obviously, my client was found guilty, so a jury believed them. So I'm not saying that they were being untruthful. They were found to be telling the truth by a jury of my client's peers. I've talked about this case before, so if you've heard this story, please ignore me. But the puzzling aspects of the case to me as an attorney was that the way that they described it, they were all in a room that couldn't have been more than, I went inside, I was inside the room. It couldn't have been bigger than maybe 300 square feet. There was a bed, there was a door, you walk in, at the foot of the bed, there was a television. It was like a medium to largest size television. There was space on either side. The children were laying on the bed. My client was in there with his girlfriend, like sitting on lawn chairs. There was other people on the other side of the bed, adults, all of them. One of the kids was at the foot of the bed. And so whatever was alleged to have happened would have had to happen in full view of all of these adults. And so one of my theories of the case is like, look, if my client is guilty, then all of these effing people are guilty. Every single one of those adults had a duty to protect those children if they saw something like that going down. And not one of those individuals came to these children's aids. Why? Because they didn't see it happen, because it didn't happen. And there's a whole timeline of events and stuff like that. Now, the reason why my client lost this case, and again, I've told this story before, because all of that sounded really good. Every single one of those witnesses came, yeah, I was in there. I was in there the whole time. I saw him come in. I saw him leave. I was in there the whole time with the girls. I didn't see anything like that. Now, the DA's argument was obvious. All of these witnesses are biased. That's his son. That's his, family member, whatever. That's his girlfriend. Turns out on one of the last days of witness testimony, the girlfriend gets on the stand. And she lets out what I had no idea had happened. My client was he was out on his own recognizance. That means he wasn't in prison. So he was home. His old ex-girlfriend, they were obviously no longer, I don't know why it's obvious, but they weren't together anymore. But they were talking on the phone. I didn't know that was going on. She went to his house the night before she testified. And she testified to that on the stand. And she testified that they went over some of the testimony that they had talked about. And I had no idea when I was prepping her about what I was going to ask her that any of those things would happen. That came out on cross. And it came out on cross just because of some of the stuff that she was saying. And at that point, lost all credibility. And they deliberated for 3 or 4 days. I don't remember. I actually thought that it was going to be a hung jury. Usually those kinds of cases, they're either right away, couple of hours, 6 hours, they come back guilty, or it's going to be not guilty or hung trial. So I was fully expecting to win, and I was fully expecting either that or a hung trial. They came back with a guilty plea. So they deliberated their asses off. But that's why they lost. My whole point of telling that story was not because of my personal story of victory or that one of defeat. It was because the most terrifying aspect is how do I cross-examine these girls without seeming like a monster? I can't just go in there and call them a liar. I can't just like yell at them on the stand. They're children. One of them was in college, 18 or 19 years old. It was like 5 years after the incident. And so the other ones would have been like 12 and 13, I think, maybe 14, but they were kids. You cannot go in there and start yelling at kids or mad dogging them or staring or treating them like they're liars, because the jury will hate you and they'll hate your client even more. And so I was very delicate. I talked to them like I was their friend. I didn't ask them accusatory questions. I just was trying to highlight and emphasize discrepancies in their stories. Like for example, one person said, "Oh, well, he did this," and the other said, "Well, yeah, but no, he didn't do that. He did this." It's like, "Oh," and I would use that in my closing arguments and refer to that in my closing arguments. Like, look, these kids were making it up. And the reason you know that is because their stories don't match. 3 of them came up here. They told 3 different stories because they didn't remember the story that they made up on the day that it happened, and they couldn't refresh their recollection with their own memories because it was a made-up story. That was one of the things that when the children were not in the room, that I argued on closing arguments. And it would have worked, but they didn't trust the witnesses, ultimately. So anyway, I am very sympathetic to this aspect of it. Extensive emotional, psychological, reputational harm. Yeah, all of those things, man. And when you get an asshole lawyer up there that's going to cross-examine you and like purposefully try to get you to cry because, I don't know, maybe he was an incel in high school and, he spent all of his time trying to study law. Now he's out and this is his big payback to get back at women. I know attorneys like that, and they're disgusting. And the last thing you want in life is to have to talk to them. And so, let's continue with this. Worse still, they chill constitutionally protected speech, deterring survivors from coming forward and obstructing efforts to expose abuse, prevent future harm, hold perpetrators and institutions accountable. In direct response to this urgent threat, the California legislature enacted 933, Civil Code 47, to provide absolute privilege for good faith disclosures of sexual assault, harassment, or discrimination, and meaningful remedies to survivors who are forced to defend against retaliatory defamation lawsuits. I have a problem with the use of the word good faith. How do you know they're good faith? How would you say that they were good faith? By saying that they're not frivolous? Because if that's the case, that's a pretty low bar. All you have to have is one triable issue of facts. All you have to do is present a prima facie case of the sex cause of action of choice and take it to jury and have them deliberate over it, have it not be summary judgeable. And you're pretty much in. I mean, to me, that is a definition of a good faith lawsuit. There was grounds to bring the lawsuit. In the same token, though, what if you have a good faith defamation case? What if there's questionable text messages? Like, what if there's retaliatory text messages in there? Like, hey, if you do this, I'm going to tell everybody about what you did. And then he's like, what are you talking about? I didn't do that to you. You know what you did. You know exactly what you did. And they're trying to make it sound like it's a thing. But the guy's like, literally like, hey, we might not know the full context of that, but in the interest of completeness, you might want to be able to bring that in. The fact that you have something like that, you could argue whatever you want. But if you have that and you're trying to argue that she was making this up, and I had no idea what she was talking about, all of a sudden I start getting threatened with the sexual assault allegation that she's going to go to the cops. She's going to say she's going to say that I hit her. She's going to say that I did this or that, and and I'm going to go to jail. I'm going to lose the kids. I'm going to lose my house. And yeah, I think that the trier of fact should know those things. And I think that if you're introducing that, it almost takes it out of the realm of frivolous, unless certain other things happen during the litigation. But good faith disclosures, what do you mean by that? And how do you define it? Critically, it targets only baseless claims. Those that fall squarely within the sham litigation exception to Norah Pennington. I talked about Norah Pennington on Friday. And the whole gist of Norah Pennington is that it has never been a thing in America to punish non-sham lawsuits. Those are reserved for sham lawsuits. If it is found that your lawsuit is a sham, for example, the Van sham, you should be penalized for that. But if you have a good faith, non-frivolous lawsuit that you want to present, nor Pennington suggests that you shall not be punished for that. That's the basic gist of Nor Pennington. Exception to Nor Pennington immunity and imposes no liability on legitimate petitioning activity. It simply removes legal recourse for those who abuse the judicial process to suppress survivor speech that rests at the heart of First Amendment protection. Striking down 47.1 would force survivors into untenable position of having to choose between remaining silent or facing emotional, reputational, and financial devastation through protracted. Hey, I got a visitor. What's up, young lady?
Oh God, good morning. Sorry, I completely overslept. I promised I wouldn't, but I did.
Weren't you just saying, hey, if you're not up at 7 a.m., I'm going to be yelling at you in the DMs the same way you're yelling at me in the chat. And you're like, oh, it'll never happen. I'm ready. It's like, okay. All right.
That's why they say never say never. Mm-hmm. Now I get it. I'm glad I could catch you. Sorry, but I'm not going to interrupt. So, hi, everyone.
Oh, well, I wasn't going to read this whole 37-page thing because I'm already 51 minutes in, which is way longer than I wanted to spend on it. I was just having a really good discussion about this 47.1. But now that you're here, maybe you could weigh in on some of this stuff. I mean, I said a whole lot of things before you got here, but let me finish what I was reading. Okay. Striking down 40, they're going to force survivors into the untenable position of having to choose between remaining silent or facing emotional, reputational, financial devastation through protracted abusive litigation. It would also send a dangerous message to other survivors contemplating disclosure that speaking out may carry intolerable risk, and it would embolden perpetrators and complicit institutions that depend on secrecy to perpetuate cycles of abuse. So, what do you mean embolden? Embolden would require that they never had that at their disposal in the first place. This is just placing a chilling effect. Look, I'm not going to say that it's not going to. What am I trying to say? I think that 47.1, if it's found that you brought a defamation lawsuit for retaliatory purposes, and that the evidence was so overwhelming as to be ridiculous that a jury would ever consider your claims, then maybe treble damages are appropriate. But I also feel like punitive damages already punish that kind of activity. Like a jury has an option. If they sit through an entire case and they look at the evidence of defamation and the other side makes it a case or a point to suggest that the defamation lawsuit was frivolous, should have never been brought to court, the evidence was scant at best as to be non-existent, and the only reason it was raised was to further intimidate my client, and therefore punitive damages would be appropriate. I'm going to ask this jury to award my client $1.2 billion because this guy is a douche bag of epic proportions. Isn't that what punitive damages is? But it's for a jury to decide those things. This leaves no discretion to a jury. It leaves no discretion to a judge. It just automatically punishes both good and bad faith lawsuits of defamation and defending these claims. What the hell is that? Just treble damages across the board. We're seeing in primetime television of the chilling effect that could potentially have, because there's been really competent attorneys argue that Justin Baldoni should knock it off with this defamation stuff out of fear of the damages imposed by 47.1. That's the very definition of chilling free speech. I don't know how else you would characterize that. What do you think about that? This 47.1 business, Anita?
What I think, well, it's first of all, I'm not American, so I don't really know the First Amendment details
Oh, it's just right to free speech. It's just
I know that, but I think it's to my understanding, this law was overlooked and nobody objected to it, right, when it happened.
Yeah. And so we're in a position right now. We got these amicus briefs. There's a few of them out there now. I don't know if they're going to get. I honestly don't understand what purpose they serve.
For me, like, so this is a double-edged sword. That's what they say, right? Damned if you do, damned if you don't, kind of thing. I do believe that people have used this, but I think the treble damages should be enough. Be like, okay, if she loses her case, then if he loses his case, then that's when it comes. It should not be presumed at the beginning stage.
Yeah.
Wouldn't you say that? Shouldn't that be like standard?
Well, my argument is that no, you got it exactly right. Like 47.1 imposes damages. It triples whatever the damages are going to be without discretion.
Yeah, and this should be like more power to Justin. Be like, yes, okay, based on 47.1, I'm willing to go all the way. Doesn't that say something about him? Even if, because they brought this 47.1 as a part of dismissal, right? Motion to dismiss.
Yes.
And that law doesn't say that you cannot sue or like you cannot defend yourself about the SH, to my understanding, or that's how I understood.
Well, it basically says this.
Yeah.
It suggests that if you bring a defamation claim in a sexual harassment case and you lose, then you will be imposed these fee shifting provisions, which suggest treble damages, attorney fees and costs. He's going to have to pay for her lawyer fees. Basically, whatever the damages that she incurs, triple it. And that's what he's going to have to pay. And the judge has no ability to make it any less. None.
Yeah, but it doesn't say it should be dismissed, right?
No.
So how is that law grounds for dismissal? I mean, it's a grounds to say that, hey, if you do lose further down, this is a possibility.
Well, if you lose at trial, is what it is.
Yeah. That's what I'm trying to say. And
he could withdraw it right now without penalty, but they'd have to work that out, But he could withdraw it right now and not have to face those. And there's been attorneys out there that have said that he should. Why? Who needs the aggravation? That's what they've been saying, right? We got the fraud charges, but there's still a lot to litigate. We could just litigate on the fraud and just leave the defamation alone because it's too risky, which is, decent advice. But if you believe that you've been defamed, it sucks because you've basically been bullied into dismissing a valid claim, a non-frivolous claim. That's the problem with 47.1. It doesn't take into account that people may actually use 47.1 for nefarious purposes, the way that Ezra has used it. And we know that she's used it this way now because she sat on the board of that same activist group that Elise came from, or whatever that organization was. She was on the board the whole time. That's bullshit. So she was aware of 47.1. She's aware of the implications. She drafted this litigation strategy to impose 47.1 on Justin Baldoni, knowing full well that he was probably going to file a defamation claim against him. It was a brand new law, and she took advantage. She took advantage.
Yeah, and now that's why I'm thinking. Sorry, and that's why I'm thinking. I really don't understand how people are saying like, oh, it's going to be dismissed based on this. The law itself doesn't say it will be dismissed based on this. So how, I don't know how this is a win, situation, motion to dismiss, besides the treble down 3 times, payment, the treble damages, right? That's what you said?
Treble damages. Yes.
So, I mean, that can be an argument that, hey, by the way, if you're still going to go forward to it with this, it's not up to the judge. No, to my understanding, the law doesn't say based on this. So I don't really understand all the chaos around it in the first place. I do understand that this is a serious, how to say, but if I were Justin Baldoni or lawyer or something, he would be like, we're willing to go all the way as a response, but it's obviously you still have to mitigate it as a lawyer.
Yeah. Which you can't, because of 47.1, you can't mitigate it. You mitigate it by getting rid of it, not getting rid of the cause of action.
Yeah. And I don't really know, to be honest. But again, I think 47.1, it is scary on its own that it has ×3 thing. And I think Bryan Freedman knew this. He's a California lawyer. For sure he knows this.
Yeah. Well, I would not be surprised if he wasn't aware of it, honestly, because it's new. Look, when you're a lawyer
I think I've read one of the things. I think he knew of it in that case. In one of my researches, he knew it, but it doesn't apply to. And he said that it doesn't apply because he lied. I mean, she lied.
Yeah. Well, yeah, but he's gonna have to prove that at trial, and so I fully agree that she lied, and I understand what he means by that, because basically she's brought a bad faith. She's gonna lose on her claim. He's assuming she's going to lose on her claim. Like, what happens if she loses her claim of sexual harassment, and he loses his claim of defamation? Then I suppose that there are no treble damages then, right? Because she doesn't have an actionable claim.
Isn't that logical? That, for me, as a lawyer, obviously you have to fight it, but I personally don't think they care about, not that they care. They're extremely confident that, the fact that she wants to withdraw her emotional distress stuff, isn't that a big sign that she's trying to slowly back away from some of the things because
I'm not so impressed with when you put an intentional infliction of emotional distress in a lawsuit in America, at least, it is very difficult to prove. It subjects you to exposing all of your medical records, all of them, records from your therapist, from your psych evals, from, whatever, all your medical stuff that people don't want to disclose. And it was kind of a throwaway cause of action in the first place. In her initial complaint, she repeated it in her amended complaint, whatever. She was never going to win this case on emotional distress. And so her not wanting to turn over her medicals, you could speculate why that is. Maybe because, I don't know, we're going to find out that she's like a batshit crazy because she got a psych eval that suggested that she was prone to making false allegations of SH. Maybe that's in there. Maybe it isn't. Maybe she just didn't want to disclose the fact that she got tested for STDs or something and have that get out leaked.
Oh, no. Oh, my God. People are still giving so much benefit of the doubt. I don't think so. I think...
I'm not giving her the benefit of anything. I'm just saying that...
Again, she didn't get her AEO. She didn't get her cease and desist thing. Or not cease and desist. It didn't go through. Exhibit A effed up all her plans. She didn't know everything was going to be disposed. I mean, what is this called? She didn't know, she probably thought they would get a gag order or something,
Mm-hmm.
And it's silly of her to think and then they would be able to. And that's why actually Freedman, the whole idea behind my theory is like Exhibit A and timeline of relevant events was a big Uno reverse because Freedman knew what they were doing.
Yeah.
And now she's trying to get out of it by many means. And she already made so many mistakes because she realized that she will not be able to, to prove IED because of what she's been doing in the PR world. Because now she never thought they would go through discovery and everything. And I think that's why they were drawing it now. Back then, when it was dropped, it was supposed to be part of the impact. And I think also her lawyers are now, they had to shift strategies midway. I really genuinely feel that, and they've been trying to get out of it. And the whole funny thing is, they cannot get out of it. They've been looking for a fall guy. I genuinely believe it. But they cannot make their PR people the fall guy, because actually those are the people who have all the shit in the world on them.
Yeah.
So if they do try to make either Leslie Sloan or Stephanie Jones, Stephanie Jones, there's no way they would be able to do it, because actually she knows that there was no smear campaign. Right now they have her on their side a little bit, because how things are going. But if Stephanie Jones makes a deal with Baldoni's side because she wants to get out, because she literally is implicated of criminal things. Does my voice sound, what is it called, raspy? I'm still waking up.
A little bit.
Sorry.
It sounds like you woke up late is all.
Hey, it's
it sounds like you
8 a.m.
slept in a little bit.
Yeah. Anyway, so like the whole thing is just crazy, because Blake knows that she cannot do wrong to the PR people. And this is like why they're like spinning in circles. And I think it's really, really funny. At the end of the day, regardless of how many documents are stricken because of something Freedman said. Oh, I have another theory about that. But Freedman, they're not backing down. And I genuinely think there was probably an offer behind the scenes, and they didn't accept it. And now, as discovery is coming,
I don't know.
They've been trying to. They're so desperate on their 47.1, because I think Ezra and Gottlieb thought for sure this will scare any lawyer. That's why they're doing the 250 million. You know what I mean? So they miscalculated everything from get-go. And Exhibit A ruined everything so much, they don't know how to take it back. Even the judge hasn't. Sorry, I'm again as usual. I may have just woken up, but I still think the same way, so that's a good thing. Or speak the same way. So the judge hasn't, in their motion dismiss, all of them, Stephanie Jones, Leslie, and Ryan Reynolds and Blake Webb, they have all asked for Exhibit A to be stricken in March.
Yeah.
And judge, when he's he could already strike this before he replies to the motion dismiss, no?
Wait, say that again?
Because they've all asked Exhibit A to be stricken in all of their motion to dismisses.
Right.
And the judge hasn't decided that he could have stricken them immediately.
Right. He
and
hasn't.
Still partially, and that's the whole funny thing. And this thing has been getting out of control for months and months and months, and they really don't know what to do. I think that's why the sanctions thing happened, because they've been trying to scare behind the scenes. Oh, I'm going to impose sanctions. They've been trying to put legal threats on Justin Baldoni, because 47.1 didn't scare them. It's not didn't scare them to be okay, I'm going to remove it, right?
Yeah.
What they're trying to, they really thought it would, because they didn't know the public would have so much information. And that's why they're spiraling. Anyway, I'm not worried. Long story short, I'm not worried. Everybody chill. I could have just said that way. Sorry. Long story short.
Yeah. Well,
guys,
I'm
calm your tits. Everything is okay. Everybody, breathe in, breathe out. I really, really, really genuinely think that, yes, the trouble, 47.1, first of all, that we are outraged, the women, because we know she didn't experience it. And as a person who hasn't experienced the fact that she's using it, this, activist groups, they should be outraged and be I know Freedman didn't ask for a motion to dismiss, but I think it should be dismissed because this will damage our action. I would write an amicus brief as a charity this way, because this is the only way how Blake is affecting this 47.1 in a bad way, not in a good way at all. Sorry.
I wanted to answer.
I'll stop speaking.
You doing okay, Anita? You're good, man.
Yeah, I just know I lost it. Like, I had a thought, but I lost it. So
I do that all the time.
I didn't even answer your question, but
I don't remember what my question was, honestly.
Yeah, that's just what I thought about 47.1.
Yeah. I wanted to answer Amy's question. What's up, Amy, from Boston, and Kelly? She's asked, how do you gauge emotional trauma other than psych rating scales from standardized tests? Only way to do show your injury. No, she has no receipts. Or am I making that up? No, that's exactly how you do it. That's why her medical records were being demanded. There was a motion to compel her medical records. You're the one saying that you have all this emotional distress. I need to know the evidence of it. Have you seen a doctor? Have you had a psych exam? Have you gone to a psychologist for a psych eval? Have you been to therapy? What evidence do you have that you are in actual emotional distress, or is that just a wayward characterization by you? The way that they teach intentional infliction of emotional distress in law school is that it has to result from an activity that is so egregious as to be just like beyond beyond anything you could imagine. Like, for example, tying somebody to a tree and then like repeatedly dousing him with water and whipping him with sticks and like making fun of him and like laser light shows to psychologically damage him while he's trapped and he can't move or whatever, some kind of crazy thing to inflict psychological torture on an individual. And it's a really high bar. It can't just be, oh, I was offended because he called me by the wrong pronoun. That's not what it is. It's something egregious. And so in the context of this case, going back to Lively's 17-point list, that would be, I guess, the source of her distress. That, or maybe because Justin recommended a personal trainer that deals in weight loss. Maybe that's what she was so pissed off about. I don't know, but she was never going to carry the day with that cause of action based on what was pled and what we know. So it has no effect, zero effect on the case at hand, whether or not she dismissed that cause of action or not. She was never going to win. So it does her no good to have it in there. So if it means that she doesn't have to give up her medical records by taking it out, that's what she's going to do. Judge Lyman made a ruling and says that, look, you guys figure out if you're telling me it's going to be dismissed, fine. You guys decide amongst yourself whether it's going to be with prejudice or without prejudice. But I'm warning you, if you dismiss this with prejudice and they don't have opportunity to go in and discover your medical records, and you will not be able to go in and talk about your emotional distress during trial for any of the other causes of action. So strategically, maybe it hurts because she can't go in to talk about how it made her sad that she was being SH'd by virtue of her 17-point list, whatever, the HR complaints, or non-HR complaints for that matter. Maybe it'll affect it that way, but she hasn't lost anything in terms of the lawsuit other than a cause of action she was never going to win. So there's that. That's why I said it wasn't that big of a deal. It's not that I was giving her the benefit of the doubt. I still don't think that she has much to stand on in terms of this case. Her case and all of her causes of action is weak sauce, 100%. I don't see her prevailing on any of the SH claims. If she did, I would be shocked by what I've seen so far. I think the real question is whether or not Baldoni is going to be able to prevail on his fraud claims and his defamation claim, because there are grounds, there are facts to put a story together that makes sense to a jury. They don't have a smoking gun. They got a lot of work to do. Anyway, I'm not worried about Lively's case, I guess. It doesn't hurt or help her case. And I think she still has a bad case, is what I'm getting at. And so I'm just not all that impressed with it. Anita, was it you that asked me about that? Why did I start talking about that? I was talking about something else entirely before you came in.
Oh, sorry. I was trying to check out if there were any new filings. I just realized there was another amicus brief.
Yeah, that's the one I was reading just right now.
Ah, okay. All right. Sorry. Obviously, I was like, oh, how does Child USA? What does Child USA have to do anything with it? They're really
well, they're an organization that's. You missed my whole like soliloquy about how I hate activist groups, and this is one of them. They claim to be nonprofit, but 95% of the money is going to like the founders and stuff.
I don't know. Again, I'm not American, but like charities out here, they don't do these things. Like, it's not a political thing. It is a political thing that, yes, you have to pass the laws and everything. It's like, with all due respect,
activism
have you read the Exhibit A? Like, with all due respect, like.
Yeah. Well, no, they're interested in shaping legislation. They're not interested in this lawsuit, honestly.
Yeah, I absolutely refuse the fact that, first of all, they're claiming that, whatever Blake Lively said is true, but they're completely stepping on Justin Baldoni's right. And all of these activist groups, basically, they're saying, for the greater good of it, it's okay if Justin Baldoni suffers through this. Because, there are people who are the real victims who will be affected by what this is happening. Like the irony of these things, like, do they think people are stupid? Like,
yes, no, they 100% think people are stupid.
And as I said, like, for once, we have like a front row seat to what happened behind the scenes, like raw messages, raw footage of everything, how people lie, how PR manipulates. Like, we can read and think for ourselves now. Yeah. They cannot pull this shit, especially in this case. And it's how to say, like, it's gaslighting. Again, literally, I don't even have any other word. And that's why, like, I don't it doesn't enrage me as much as it enrages everybody else, because I think the intention here is clear, to gaslight and think that actually this is not even about Blake Lively. This is like they're trying to pull on people's emotions. But now we have so much information. We're like, no, you don't get to do this, not anymore. So
that's why I say, that's why I say these amicus briefs, they're not about, they're really not about the issues in this case. They're just trying to like advocate for their specific groups. That's a dangerous thing. MG says that this is because Blake Lively is now stuck between a rock and a hard place. She drops her claims with prejudice. She can't use her emotional claim after discovery, or she opens up her medical info to be Bryan Freedman. Screwed. She's never going to be able to say ever again that she was distressed emotionally in the context of this case. So it hurts. It certainly hurts in that regard. Let me get to this one. Ricardo says, I have opinions. I trust your insight to shape it. Oh, you place your trust in me at your own peril, Ricardo. How about that? Alessia, thank you so much for becoming a new member. Welcome to the family. Ricardo again says 47.1 needs a jury discretional mechanism. Yeah, I had brought up the idea of having like an initial like probable cause hearing or something similar to that, like they have in criminal court, to at least make the judge believe that there is enough evidence to go forward to trial. And if not, then stiff penalties, maybe then treble damages. I don't know. But I 100% agree with that. Ricardo again with the 5 says, a lawyer said that Lyman could rule, but the case not be published as to not set precedents.
I do have a question. Oh, yes. Sorry. After that. Sorry, my bad. Oh, please answer that one. I didn't.
Yeah. No, I agree with that. It can't, even if it's not published, people are going to know about it. It's going to be persuasive. People are going to talk about it. And it won't be authority, but it will be persuasive argument is what it would amount to. But what's the point of that? I mean, I don't know. Whether it's published or not, I don't know, but I guess we'll see. I couldn't imagine it not being published, as it's one of the highest profile cases dealing with this specific law out there right now. So, we shall see.
Do you think there is this thing that judge could do? Because first of all, Baldoni, like everybody's talking that, this would completely dismiss Baldoni's whole lawsuit, the not the counterclaim, but the one that he filed as a separate case, the one that was consolidated, that has so many causes of action. He didn't just say, "Oh, she defamed me," like she's been extorting me.
Right.
Well, what is like everybody's completely like, I don't know, they're saying that that case should be dismissed or whatnot. But my thing is, as a judge, because this is a completely new, what is it called? What is it called? What is this?
What are you trying to say? I'm not sure what you're trying to say.
What is a 47.1 in legal terms? What is it?
Oh, it's a brand new law. It's a brand new statute in California.
A statute. That's the one. That's the word I was looking for. So, since there is no like cases to refer to, would it be fair to say that okay, then the judge can ask, based on this 47.1, would you like to drop your defamation suit? Could he like ask, them, and then be like, yeah, would you like to? Because this is it doesn't have any precedent, let's say, right? It's just and he does realize how this is like quite
no, I don't think that would ever happen.
Again. But can he say that I will dismiss it with prejudice, and if we go further down and he Baldoni can prove, he can claim it back, or like he can sue later on. Is that a possibility?
No, it's either in or it's out. So he brings us with a if he dismisses without prejudice, fine. I guess you could bring it later, but I don't know. It's not going to get rid of the entire lawsuit. I think that was part of your question.
No, not entire. No, that was not my question.
Okay.
Like I'm saying that there were so many causes of action, right? So this is just the defamation, but it applies to only to 47.1. It applies only to the defamation part, not the other causes of action.
Yeah.
Right?
Yes.
So wouldn't the judge say that, okay, let's pause this cause of action.
Like reserve
let's
on
dismiss
it?
This. Yeah. And then we can
the judge would never say that.
Once.
Well, the judge would not on his own motion.
Isn't that logical?
No, it is not.
Why not?
Well, the parties are responsible for doing that. If Baldoni wants to do that, he can do that. If he wants to dismiss it without prejudice,
he can advise.
The judge can't give legal advice. He cannot give legal advice. And he would not give legal advice to these two very powerful sets of legal teams. He wouldn't even give legal advice to pro pers. He might say that, look, the other side has requested whatever. You have the option of dismissing this, and if you don't, then it's going to be set for trial. He might just talk about the ramifications, but he wouldn't advise like that. That's not the judge's place in an American courtroom. And he would certainly not do that. He might hint at that. Like he might suggest, like he's done that in this case already, like where he said that, look, if you guys are thinking about amending complaints, you keep on telling me about how you could have done the complaint better, so amend it then. I'm not going to grant you an extension. It seems like you already know. Like he's tipped them off in that regard. But he would never just like have let me rephrase. Maybe he would, like in chambers, like talk to the attorneys off the record and just say, look, you really should consider dismissing this. But it would be as a result of like him talking with the other side and the attorneys, and have like a conference between the three of them and like discussing aspects of the case. But I can never see Judge Lyman putting himself in a position to advise Baldoni to drop the defamation cause of action without prejudice so that he could bring it at a later date. That's just, we're here now, let's do it now. I wouldn't advise that as his attorney. We're either going to go for it or we're not. So what, we're going to finish the...
Based on what you're saying, then he would do the same for, what is it called? Blake Lively's attempt to get the emotional distress dismissed. He's like, hey, if you want to dismiss, it will be with prejudice. That's what I understood.
Yeah, but you can't raise it later, like after the lawsuit is over, I guess. I think that was another part of it. Like once the lawsuit is over, like they've been to trial. All right, now let's do now let's bring up the emotional distress claim. You can't do that because that's like, you don't get two bites at the apple like that. So if they're going to bring it again, you dismiss it without prejudice. But if you're going to reintroduce it, it has to be in this lawsuit. It can't be after this lawsuit is over, then you're going to bring it up some other time. You can't do that. It's res judicata. It's already been litigated. Whatever your issues are in this time of events, this incident, whatever brought rise to this incident, you have to get in all of your causes of action now. You can't like bring in the causes of action piecemeal at different times. Otherwise, we're going to be litigating for the next 50 years. So they try to do that to expedite these cases. Does that make sense? Does that answer your question?
Yes and no.
Okay.
It makes sense. I understand how that works. But I thought the law is supposed to be logical, but it's not logical in my like.
Well, it's logical. Okay, so put it this way. Like, what if we just reserve it on every single individual cause of action? And then the first cause of action is going to be the fraud. And then we do a whole trial and go through 2 years of discovery and trial. And then after that, we bring another lawsuit for defamation. And then after that's done, we bring another lawsuit for, I don't know, all of the other things, breach of contract. And after that's done, we bring another lawsuit for whatever the other thing was. And we just do them all in a row. You're going to be litigating for 50 years. That's stupid. That's illogical. And so to prevent against that and to promote judicial economy, they say that whatever your issue is with this person that arose under this timeline of events, you get them all in now, or you waive your right to bring it later. If you try to bring it later, you will be stopped from bringing that as a separate lawsuit because of res judicata, meaning you don't get 2 bites at the apple. You get one shot at this, do it now. So if they dismiss without prejudice, they can dismiss it, but raise it at another time, so long as it doesn't violate any of the deadlines for when are we going to trial? October of 26?
No. March.
February 26? March. Was it? Yeah, March of 26. Yeah, that's all that means. Rob has a quick question. Omar, since she played the emotional distress card, if this goes to court, can Freedman ask questions about it and what it was all about? Yeah, he can, but he won't, because then it will be opening the door to some of that stuff. And why would he do that? Because then she's going to be able to talk about all the emotional distress that she suffered, and he will have no evidence to refute it because he didn't get to do discovery on the medical stuff. So he would never open the door that way in a trial. If it's, there's no benefit to doing that because she's just going to get up there and lie. Anyway, since this turned into like a Q&A, what do you think about my mic is all screwed up. You said you had some juicy new things to talk about with respect to.
I have so I have kind of expanded on my theory a little bit. So far I've been trying to stay like with direct quotes and everything, right, on my theory. That's what I allege that my theory is based on like 70% like direct quotes from the law filings, including Lively's as well, not just Exhibit A. And based on my research, like I backed up my theory using direct quotes from the parties involved. And I say that it's like 10% logical conclusions and 5% a bit of my attitude, kind of. That's like my theory, that this is how my thing came. So I kind of expanded and I stepped like, so that's like the clean version of my theory, but then there are things that are completely not confirmed but still fall into my theory. And also now that she's trying to do the remove the IED again, now I thought, oh, that makes sense if the juicy, anyway, sorry, I need to learn how to speak better, but
You're good. Just take your time. Breathe.
I haven't updated the website, so.
Oh, well, I published it anyway, so people can know where to find you.
Thank you. But this is like, I have rebranded, I've rebranded myself in a sense that, so that like people who are seeking information on the case, they can come there and read, because there are more than 3,000 pages at this point. Anyway.
One day Anita's brain will be in the Smithsonian.
It's hurting my brain is hurting me at this point, so I gotta let it go. But so one step further, this is my thing. This is more gossipy, more juicy, but many people have spoken about this, not now, but back in the day, apparently. So this is not confirmed. This is completely gossipy, right? I'm just giving a disclaimer. But
right.
So there's this whole thing that Blake Lively and Ryan Reynolds have had spoken about, or like have come to the case where they would divorce like every year on, like, basically, you know, this is how they are apparently behind the scenes. And there are these insiders and gossip, like people who wrote, what is it called? Blind items, you know?
Yeah.
And they're like, it's rumors. But this is my thing. I think they finally agreed. Blake finally agreed that they would divorce, but under one condition. Ryan, like, she was gonna get her big moment before they announce her, you know, because they have 4 kids. They're the lovely couple, you know, before they do that, oh, behind the scenes, we're co-parenting, blah, 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 the statement. This is my theory. That was gonna happen under one condition, that she wanted to get her big break so that they can, what is it called? After that, she's such a big star, she's untouchable, you know, just like them. This is just like them, meaning Ryan and Taylor, because once they would divorce, she has nothing kind of as a TV star to be able to maintain her status without being the wife of Ryan Reynolds. Okay, so this is the thing, and it also shows, again, this is gossipy, I told you, but it will make sense. It will make sense. Oh, it makes sense to me. And that's why I think even Ryan Reynolds has had enough of her shit, you know, but in public he has to support her and all of these things, because Blake Lively also has a lot of shit on Ryan Reynolds. She's like a master manipulator with everything. Like she doesn't care who she damages as long as she saves herself. That's one thing.
Okay.
And I'm trying to filter my thought just not to get off track. I have a bulletin point in my head now, but basically, so when she joined this whole thing, I think that's why they went aggressive. That's why from the beginning of production, like, they had that set. They thought it was going to be easy from the beginning, because they thought that, oh, she would get creative, because, you know, Baldoni was cooperating in the beginning. But then once he started kind of saying, oh, no, we're not going to go that way, that's when they went aggressive, because like there was no way that Blake Lively was not getting this movie. This was like a big golden thing. That's why they became aggressive. That's why in the middle of the whole thing, there was the sexual allegations, because Baldoni like basically had the power to say, bitch, sit down, this is my movie. But the only way that they could kind of disarm him and make him like, threaten him into submission so that he follows Blake Lively's commands, was sexual harassment. Because that's the thing, you know, it's like, everybody's scared of it. I am scared of it, you know, as a woman. Like, if somebody accuses me of sexual, like, I would be scared if somebody had that against me, blah, blah, blah. Further down, the PR things happened. And like, Ryan Reynolds was supposed to buy the rights to the movie. That's one thing, and make this her Blake Lively's big thing. It was a very successful movie in the sense that it was like more than 300 million forints dollars in the box office. And then after that, I told you, like, they went quiet when they got the phone, but they had to go after him despite him having the extortion things, and they prepared this whole thing with the 47.1 because there was no way that Blake Lively wasn't going to get this movie. That was like their whole thing. And that's why I think Ryan Reynolds also like pushed and called him a sexual predator behind the scenes and everything. He's like, I need to get the fuck out. Like, I don't care who I'm defaming. I need to get the fuck out of this marriage. And in order to get that, I need to give Blake Lively what she wants. You know, I can't believe I've come to the...
You think that Lively was extorting Ryan Reynolds for a divorce or conditions of a divorce?
Sorry?
And that's why.
Can you repeat yourself?
Okay, so are you saying that you think that Blake Lively was basically extorting her husband to help her secure the rights to this movie so that they could get a divorce, and maybe she would make concessions in the divorce?
Yeah, I think not extortion. I think it was probably part of their conditions, right? So like,
well, it'd be extortion because, like, if they don't got a prenup, like, she's gonna get half of his shit.
Oh, they have a prenup apparently.
Oh, okay.
But it's not. To be fair, it's not really confirmed nor denied, kind of. But Ryan Reynolds said that, we don't have a prenup, but we know they lie, so you can't really. He had said they don't have a prenup in a, what is it called, in a show.
How much is Reynolds worth?
According to, like, his businesses are worth more than billion, but I think his own net worth but the businesses are evaluated for their market value, not the share that Ryan Reynolds has, but around 350 million or something, to my understanding.
So it's worth hundreds of millions of dollars to get her to concede on not going after the businesses or her community share of the businesses or half the assets. And so maybe she says that, you know what, you help me do this, then I will sign off on a judgment of dissolution that makes it your separate property and you could keep it. But I want my career, I want my franchise. That's the only way it makes sense to me.
Yeah, that's the thing. You just say that, if, like, okay, there's no way we're divorcing because she knows that then, like, she has already become a stay-at-home mom for kids. She needs to care, like, for that part, you know, that I can agree that this is what happens. I can understand. Like, I have no problem with her wanting the franchise, right? So all the power to her. If you have the connections and everything, find the right movie. You have all the money to produce your own film. But no. According to her own words, she says that, I like to get a ready script and then dissect. This is all her words, you know? This is all direct quotes from her. And okay, I have another wild thing that...
Well, maybe, what about this? What about, like, them being... I can't believe you got me doing celebrity gossip, Anita. What the hell? What if?
No. You need to... this should be your... What is it called? Guilty pleasure. This should be your guilty pleasure. This should be your guilty pleasure.
What
celebrity
if...
gossip.
Well, here's what I think. I think that Lively and Reynolds are a business. Their marriage, even if they don't like each other, they're a business.
Absolutely.
And they're together are a brand, right? I mean, I don't know what's going to happen to them after this lawsuit, but they're more valuable together than they are apart. I mean, I guess until they move on to, like, the next power celebrity partner, I guess. I don't know.
Again, this is all goes to my theory, because, like, this is the gossipy part. I gave that disclaimer. I'm not claiming this is the fact, right? Yeah. For me, it also makes why she doesn't want medical records to be exposed, or, like, her therapist, because it will show she had things in her marriage, which will also open the floodgates to ask, what was happening. She loves to talk. We all know that. I think it would prove a much further thing. And this is the part. So there's this blind item YouTube page. Again, I don't agree with everything he's saying, behind the scenes. One thing we know was that Ryan was controlling, and all his exes have come out of it as well. Blake Lively, like a person who loves the spotlight, all of a sudden became a stay-at-home mom. They have claimed that, they never take movies at the same time. This was like, they don't work at the same time because they want to be there for their kids. So, and Blake Lively accepted this project when she was like 7 months pregnant. Just to let you know, so I'm trying to reason like why they were so motivated, right? These people have the money. Why did she accept the role when she was 7 months pregnant? Why did Ryan Reynolds ask Justin Baldoni if they could bring, like, try to accommodate their schedule so that because Ryan Reynolds was shooting a movie in London, and he asked Justin Baldoni, can you make it like 2 weeks earlier, the production, like it is all in the messages, because Blake Lively needed this project. They want all in because this was going to be her moment. And another thing is that, so August thing happened, right? So they were planning to basically talk about her sexual harassment behind the scenes, but not in a lawsuit way. According to my research, you know how she was nominated for Omar. Are you with me? I confused you, but
No.
Are you with me? So this is the
I'm
part
with you.
I have a thing.
What was the thing you just said? You said Omar K. What was that?
No. This is the part I know. So this is the part.
Yeah.
According to my research, the Time 100, right? They choose their nominees in September, by the way.
Okay.
So she was announced Time 100 in January or February, I believe, 2025, right? And I think they vote on it later. But their candidate list is narrowed down, to my understanding, in September, okay?
Okay.
Sorry, this also goes to premeditation and malicious intent. I don't know legally, but in my opinion. So I think basically this was her like, she was going to be a Time influencer. Like, she had such influence. She needed the double win, the franchise, and also, I was sexually harassed and I spoke about it, spoke up about it. Like, this was going to be her exit moment, because once that's done, she will already be untouchable. She's how to say, she's so powerful because, she spoke up about sexual harassment, and she has the franchise, so that when they do divorce, she already has monetary, how to say, incentive behind her to do monetary value to projects.
Okay.
Anyway, so in September, according even to Time 100, they choose their people then, and then it was announced. When she was announced in Time 100, she was given the award for something that she did back in 2019. And then, but when she gave her speech, she still spoke about sexual harassment. So
I remember.
So the whole thing is just very fishy, because that was her plan from the beginning, right? They thought she would be doing this talk about this. But then Time 100 couldn't give her award for speaking up, because, like, literally it's like she couldn't, because Justin Baldoni has said that, no, she's lying.
Yeah.
You know what I mean?
Yeah.
But then she still wanted to speak about it in her, like, she didn't even touch the points of the 2019 thing that she did, apparently. I don't even know at this point. So for me, this just shows that this was premeditated in a plan, in a way that she was going to get this movie, she was going to be time 100, like be in the list, but they effed up with everything because they anticipate Exhibit A, obviously. And Friedman, like, he was ready just in case for a gag order. So that's why he dropped his, screenshots, so that they're not silenced behind the scenes. She never thought she would have to disclose any information. I'm telling you, they thought that, extortion versus sexual harassment, for sure they will, settle behind the scenes, and then they will make a statement, blah, blah, blah. And Blake Lively goes on her merry-go-round, whatever.
Okay, but they're still like allowed to the fraud allegations.
Yeah, but I'm just saying that fraud allegations, I think it's still going to go on, right?
Yeah, it's not affected by the defamation. They could dismiss defamation,
So that's
still have the fraud.
That's why I'm not worried about the 47.1 in that case. Worst case, the defamation gets dismissed, right?
Yeah.
But his what is it called? Like, even if it gets dismissed, that defamation part, yes, it would be shitty, but Leslie Sloan still defamed him, and Ryan Reynolds still defamed him.
Yeah.
It would only be dismissed against Blake Lively, no?
Well, if it dismissed against Lively, then sure. You'd have to direct it.
Yeah, like, worst case scenario, the defamation part gets dismissed.
Yeah. Well, the reason why I have to thank Talk Time with Amy for gifting 5 Tilted Lawyer memberships. Thank you so much for that, Amy. You're such a sweetheart. Yeah, they'd have to craft the litigation. They could get rid of the defamation and still be fine. That's why it's been suggested by other attorneys that, hey, don't want to deal 47.1, just dismiss the defamation, whatever, proceed on the fraud. Same effing thing. You almost have to prove the fraud for the defamation to work anyway. So why not just go with the fraud, come out with the same result, strip off the treble damage risk, and proceed as planned? I think that's the thought process, which I don't even necessarily disagree with. My issue with 47.1 is constitutional. I don't want to talk about that more because I know that we're now the gossipy part of the show. So,
hey, I know it takes you a while as a lawyer. You're like, no, I am, what is it called? I am bound by my ethical thinking or anything. I know.
Well, it's like everything you're saying is, okay, well, how am I going to prove that? Like, how is this even relevant? Like,
it is all in the things. It is relevant. Excuse me. It is relevant.
No, I'm not saying it's not relevant. I'm just saying it's not the question whether or not it's relevant or important. It's like, how am I getting this into a trial? That's where my mind goes.
And
like,
yes,
for example, like
I understand,
90%.
But they have to prove this to the jury, and jury love gossip, right?
The question is not whether the jury likes it. The question is whether or not the judge is going to let it in. That's why, like, you could tell the jury will love it.
It goes to the state of mind. It goes to the state. It is not offered for the proof of the matter. It goes to the state of mind. I've been watching Karen Reed and Judge Bev. See, I can speak legal terms too sometimes. Yeah. It goes to the state of mind because text messages, they're offered as to state of mind, not of proof.
I'll tell you how that argument is going to go. You're going to say that, and they're going to be like, yeah, but its prejudicial effect far outweighs its probative value, and you don't have any modicum of proof to suggest anything you're stating is pure speculation. It's inadmissible. It's not coming in. That's what the judge would say, and the jury would never get to hear it.
It's in the messages. It's in the messages. That's the thing.
It's in the messages, and the way that you get it in is by introducing the messages and getting the context. But you can't just like.
And then the person, and Blake Lively reads it on the stand.
If she reads it on the stand, then then it's in. Then she's opened a door. But you're not. See, my mind, I'm not saying it's irrelevant. My analysis when you say stuff like this is, how does this become admissible in court? Like, how could I use this in a trial? And so, like, a lot of the things, like, we speculate, like, for example, the theory about Reynolds and Lively's wanting to get divorced, but needing to find a way out and incentivizing it and lively possibly extorting Reynolds into helping her with defamation, or else she's coming after all of the community stuff. That is pure speculation. And unless you got a tie-in with the text or something else, you can't even mention it. It would be objectionable.
Yeah. And I think, like, you know, like with the therapy and everything, you know, if she did go, or her medical documents and everything, I think this is like, that's why they're trying to get dismissed a few things, because they're, you know, how to say, they don't want any information to be out about it, you know?
Right.
And this is my theory. This is my theory why they want to withdraw, because this would open the floodgates to like further prove their premeditated.
Well, since we're speculating, what do you
plan
think would
to
be
take
in the
over?
medical
Plan
records?
to take over. Sorry.
What do you think would be in the medical records that they're hiding? Since we're speculating,
I think like there could be that maybe like a doctor has diagnosed her with pathological lying or something like that. Like I really so I don't know. I don't want to call people narcissist medically. I am happy to call it, how to say, from outside how it is. Like, you know, you never take the blame for what you did. You find somebody to blame, you know. So it can show like to her, if there's something that shows her personality, right?
Like she has a natural proclivity for untruth.
Yeah, and actually Bryan Freedman had in the footnotes in his I think January 16 filing, he had said that, you know, just from the get-go, Blake Lively had made a statement that to Justin Baldoni, "Oh, you have too much power." That's what she had said that from the beginning when they met, like before she even signed on, right? So when they were meeting, they didn't have this plan, I think. So I don't think they had this plan to make him to be a sexual predator from the get-go. That came to be once she started seeing resistance and realized that, oh no, before we go to post-production, I gotta do something about this, you know, otherwise I cannot do anything in post-production. And so basically they started slowly bullying Baldoni with like little things, to the point that she couldn't be fired yet. She's never signed the contract, right? She stood, according to Bryan Freedman, to this day, she never signed the contract.
And that was intentional on her part.
Yes. Yeah. Because that would be like, she doesn't have to promote the movies. She couldn't do anything, you know, and that's why, because she didn't sign the contract, and it was all part of the extortion part. I mean, in the extortion part of the case. And also it can all of this together, right? I'm sure Freedman can find a way to weave it all in together with text message or something that insinuate this and falls for, like, how to say, it makes sense. You know, if it is in the text messages, it could be admissible. It doesn't have to be that, oh, she said that, oh, let's take this man down, or in the divorce, I'm gonna out you as a gay person to Ryan Reynolds or something like that. You know, like, it doesn't have to be in that direct way. But wouldn't it be relevant if there are text messages kind of insinuate that, and it's state of mind of Blake Lively? And wouldn't that be admissible in court, where they can find text messages that back up their claim, not in direct quotes, but kind of it can make sense together?
Well, you have to think of relevance in terms of what element of what cause of action are you proving. I say state of mind. Now, state of mind as to what? Like state of mind as to defamation, like state of mind as to reckless disregard for the truth, a state of mind as to intentionally perpetrating a fraud. What specific state of mind are you talking about?
State of mind that they were going to get this movie one way or another.
So I want you to play attorney now, because you have this great theory. You're not going to have time to just rattle that whole thing off to a jury, because they don't have the attention span.
Freedman is better spoken.
He
Obviously,
is.
like right now, I'm freestyling, so it's not fair.
I know, but you're going to have to boil all your thoughts down to 3 main points. What would be your 3 main points?
My 3 main points.
Yes.
I would like to prove to the jury or to the...
That you have to prove to the jury. They're the trier of facts.
Okay. They were going to get this movie with any means.
So then your first point is the motive behind the fraud was they needed to steal the movie. That was their motivation.
Her motivation.
That's
And
your
Ryan
point number
Reynolds'
1.
motivation was desperately getting out of this marriage.
Is that your point number 2? Is that the most important point?
No, that goes to my point number 1. This goes to my point
subsets.
number 1. What was their motivation?
Yeah. So what's point number 2?
My point number 2 was that she needed creative control because she wasn't getting it, as per text messages when Baldoni says that, we will still go like with the writers thing. Thank you. And then she gets offended. When she gets offended, she brings in her dragons as a threat.
Okay, so stop right there. You have a brilliant point going. You have a brilliant theory of the case going. So she needed to steal control of the movie. And the mechanism to doing that was by wrestling away creative control. Now, what's your point number 3?
My point number 3 is, so first one was, by any means, I'll get this movie. The second one was, in order to get this movie, I need creative control.
No, by any
number
means belongs,
3.
Okay, check this out. By any means does not belong in point number 1. Point number 1 was the motive was we need to steal this movie. Number 2 was the mechanism to do that was by wrestling away creative control by any means necessary. That's point number 2. And now point number 3 would be what?
To the jury. Wait, I'm trying to make it into 2 sentences. Just 1 second.
I apologize for doing that. I'm trying to get you to frame your argument in a way that's appropriate for
number
trial.
3. She took over the movie. Case in point, the fact that Baldoni was like not any part of the promotional part, like this is the 3. And then the public turned against her. And she needed somebody to blame because she didn't expect this. There was a miscalculation on their behalf. So she wanted to blame somebody. And the reasons of sexual harassment that she used to take over the movie, she brought it up because in the text messages she saw that they had like extortion and everything. And this was preemptive to protect herself because of 47.1. This would be number 3.
So check it out. This is your theory, boiled down. We did it. We've done it. They had a motive to steal the movie to create a franchise. The mechanism to doing that was by wrestling away creative control by any means necessary. And when they found out that it wasn't going to work and that they were in violation of all of these contractual provisions, and when they saw the writing on the wall that Justin Baldoni was prepping his own lawsuit for potentially breach of contract, fraud, and defamation, she filed a false sexual harassment claim as a prophylactic measure, taking advantage of 47.1, knowing that it would make it more difficult for Baldoni to succeed. That's what it is. We did it. Fist bump.
I'm happy you like it, but it makes me so sad that there's so many details not spoken about, but I get it.
That's your opening salvo. Now, all of the details, they get to come in because you're going to need all the details.
I have to tell you something. I have to say, so I have to tell you something. So
Okay.
on my channel, I have released like 2 videos talking about my thing, and imagine me talking. At least you are here to check me, be like, oi, 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 like stop rambling there. I just go on spirals, and you know, and
I
people
know.
like some people I understand, like I completely understand. I am not trained in this. Like I don't even know how to like. It's just me and my thoughts, and somebody gave me a microphone they shouldn't have, and I just started speaking. That's the whole thing. So I
By the
read the
way,
criticism.
what is your YouTube channel?
Oh, it's Anita does sleuthing, but I've rebranded myself. So I've rebranded myself. I'll tell you,
okay.
because I want to be taken more seriously, because Anita does like the reason why. So this is supposed to go until March. My theory is that there will be people coming in like halfway through, and like nobody wants to read all the filings. The reason I have so much information, because I was reading this on the go. I'm not going to sit down and read 3,000 pages of like filings in August, you know what I mean?
Understood.
So that's why like we know this much information, but I have so much to say, but it's so hard to just say it in 2 words. Anyway, so I want my information, my YouTube channel and website to be there for the, like, that's why I don't want to include gossipy stuffs, because I don't want to how to say, push away people who are looking for information. I've added a bit of my thoughts, inner thoughts and everything, you know, but I'm trying to keep it factual and not to get triggered and be like emotional and angry towards Blake Lively and everything, because I think what I'm saying makes sense. Here I am like, you know, bitching on them, but you know, that's a different case.
Well, let me give you a little bit of advice. I think that you're starting your YouTube channel. That's brilliant. And you're going to beat yourself up about how you're, you know, all over the place and this and that. You're not good at this and you're figuring out. Don't worry about that shit, man. Just post your videos. You're going to get better. When I started this channel, I don't even know how long ago it was, 3 years ago, 2 years ago, maybe. I was really bad at this, man. Like the editing was bad. Like the sound was bad. I didn't know how to talk either. I knew how to talk in court. I didn't know how to talk for YouTube. You get better as you go along. And then when you're ready, you might not have that big of an audience, but as you're getting better, or while you're getting better, that's a good thing. You don't want to have a huge audience when you're just like learning the ropes. And so these are all like practice runs, because eventually you're going to get a really big audience. It happened with Laura Knighty. Laura Knighty got like worlds better from where she is now to where she was a year ago. She's like 1,000,000 times better, because all she does is post and bust her ass and doesn't worry about so much stuff. And yeah, you get self-conscious about it and you worry about the way you sound and the way you come off and whether or not you're saying this or that correctly or incorrectly or who you're offending or whatever. And then you got to deal with comments and people that are offended by things you say, or people that think you should be more offended at other stuff. It's ridiculous, man. You just go out there and you do your thing. You do your thing. You're going to get better, and just plan. There is an ascent that is happening, and you're at the very beginning of it. Just keep it going. Don't be afraid to post. Don't worry about you having all of these scattered thoughts. You're going to get way better at telling your thoughts in the future. Maybe a month from now, maybe a year from now, maybe 5 years from now. Just
thank you. I appreciate the Oh, thank you. I really appreciate it. I just want, like, the past 3 weeks, I have been like binge watching storytelling videos, how to write the script. I've written now, like, my theory has become a 10-part video. I've made it into 20 minutes so that to stop, I've made it not to 40. Like, I've written scripts, like, I've listened to people's like criticism, but they were actually constructive. Nobody was mean. So luckily I didn't cry yet. I haven't cried yet. So hopefully that doesn't happen. But so I've made like into 20 minutes so that whoever is coming to get information,
I noticed that
they don't hear like so much of my anger towards Blake Lively and everything. I just want to keep it back like on the facts. And my last video is like a closing statement, like proving my theory. I have written it out, how they would lay it out. I just need to, now I'm learning how to edit. I've downloaded like, oh my God, this is, I would rather type in Excel tables than edit a video. So it's like
No,
very confusing. Oh my goodness.
Keep it simple with the editing, man. I got involved with like Adobe Premiere Pro or something like that, like these professional, and trying to like learn a whole nother software. I used to do that stuff. It's just way easier just to put stuff up live on StreamYard now without all the editing. It's like, you know what? I'm doing it once and not at all. And then I forget about it and it's done. But no, you're right. You got to learn all those things. You'll figure it out. By the way, Amy says, amen, Omar. I started like Anita being on other people's panels. See, it's a thing. And Talk Time with Amy, she's about to get monetized. I think she's up to like 900 subscribers or something. I'm trying to help them. I want to get them to 1,000. I mean, I can't get them
am
anything,
almost 900 subscribers already, by the way. My
Really?
videos have I have like 5,000 views on my, like, it's crazy. It's crazy. Oh, I have 840 subscribers.
Oh, you're doing great. And you just barely started? You're doing amazing.
Yeah, my my first video has 4.9 K views, and that like has I have 10,000 views in total. But again, for me, it's not about monetization.
Yeah.
I mean, in Hungary there are different rules. Like, it's not even like I have a long way to go. It's not like the US, you reach this thing. So I wouldn't be monetized probably for six months or something like that.
I didn't know that.
Like, I to be honest, like, I've put so much effort into this, and then I'm asking myself, why the fuck are you doing this to yourself? Because I'm giving myself anxiety. But at the same time, like, with all the PR stuff that's happening in the world, like, also everybody, you know, likes to sensationalize, you know, the thumbnails and everything. I understand that point, because this is their livelihood. This is like the clicks and everything, and there's a topic. But my aim with this whole thing was that I want to stick to the facts. Whoever is trying to understand, you know, what's happening, nobody's going to go back and read all these filings. So I want to make a digestible content for the fact that I am fighting for the truth. You know, I started as a theory. I wasn't meant to be here. I don't know how I ended up here. I reached out to you. You know how I was hesitant to go on your live when you asked. I was like, it was my husband. He's like, no, you should go. You put so much effort into this. And then, you know, now he regrets it, because I'm never sleeping at the same time that he is, because I'm on a live stream with you. But
well,
anyway,
I'll tell you what, you're going to succeed in this because you're passionate. And so a year from now, you'll be at 10,000, maybe be at 50,000, 100,000 subscribers. You never know what this is going to turn into, man. All I know is people like you, and they follow you, and they listen to you because you're passionate, and they don't give a shit about maybe you're still getting better at expressing your thoughts. That will come. The passion is what you have that a lot of people don't. A lot of people, they're doing things that they think people are going to like. You're just doing this because you love it. And what I know about those kinds of folks is they usually succeed. And so you're going to be fine, Anita.
Thank you. I appreciate that. That takes away from my anxiety, because one of the things I hate is I hate being wrong. So that's why I'm holding back some of my stuff, because I don't want to say something that was wrong, and then it becomes that, I become unreliable source of information for those who might be seeking information about the case in the future. Yeah. You know, again,
get
my
the
whole
facts right,
aim with this is like, I'm learning. I'm definitely learning. Thank you.
It's my pleasure. But you know what, Anita, I got to wrap this up, because I know it's like 9 a.m. for you. It's midnight for me. It is bedtime I got to be up in 5 hours. So I think it's time for me to wrap this up. We didn't have as big of an audience as we're used to for the lively, because it's like midnight over here, but that's okay. We'll have people get caught up on the replay. I love you folks.
We're reaching the right people.
Yeah, the right people. The real ones are here right now, like here at midnight. 3 a.m. I know for Amy in Boston, it's like 3 a.m. over there. That is a night owl for sure. All of you folks, man, you all go and get some rest. Sweet dreams. I love you all. I will see you guys in the morning. Oh, by the way, tomorrow I'm going to be doing my live stream with Rachel Juarez from the Hot Bench. to talk about the Laura Owens case and David Gingras and all that other stuff. So, Anita, thank you so much for coming on. And I would tell you to get your rest, but it's time for you to get up and seize the day, you know? So
Yes. Good night.
good night to
Bye,
you.
everyone.
And everyone have a wonderful night. Bye-bye.